5 seconds. Start. These present batch of appeals have been instituted by the unsuccessful appellants being aggrieved with the impugned judgment dated 20th March 2013 passed by the division bench of the High Court of Jammu and Kashmir in State versus Pankajeshwar Sharma and placing reliance on its judgment dated 12th March 2013 cognate LPAs at a later stage were disposed of. The case has a checkered history, and in order to appreciate the grievance of the appellants, it will be necessary to glance through the relevant background facts. It is the third round of litigation arising out of the selection process held pursuant to an advertisement dated 25th February 1999 issued by the second respondent Director General of Police, Jammu and Kashmir State, inviting applications for the post of Sub Inspector of Police Executive, the post which is included in the schedule appended to the J&K Police Executive Rules to be filled by open selection in terms of the procedure prescribed under the rules. Admittedly, it is neither provided in the scheme of rules nor mentioned in the advertisement notice that the merit list of the candidates based on the written and viva voce test is to be separately prepared for the provinces of Jammu and Kashmir. It reveals from the record that the last selected candidate from Jammu province secured 56 marks, whereas in Kashmir province, the last selected candidates secured 50 marks. The second respondent, under its own assumption, published the select list of total candidates of 252 province wise, that is, separately for Jammu and Srinagar on 20th April 2000. The unsuccessful candidates challenged the selection process by filing SWP number 567 of 2000 on manifold grounds inter alia that the select list which was prepared province wise is not legally permissible, and it ought to have been prepared as one select list for the whole of the state of Jammu and Kashmir, as the post of sub inspector is a state cadre post, and therefore the selection ought to have been made by treating the state as a unit and not on the basis of residence of the candidates of Jammu and Kashmir provinces. The writ petitioners succeeded in persuading and the learned single judge by judgment and order dated 16th October 2000 allowed the writ petitions with the direction that the select list be prepared afresh of the state J&K, and those who secured 50 or more marks in the revised select list be considered for appointment without disturbing the appointments already made. Against the order of the learned single judge, state respondent filed LPAs before the division bench of the High Court, and the division bench, by its judgment dated 19th August 2002, modified the order of the learned single judge with the direction to redraw the merit list statewise, and on redrawing the merit list, if the candidates who have already been selected, appointed, and come within the merit zone, they should not be disturbed, but their seniority would be determined in accordance with their placement in the order of merit, which would be finally prepared. The above order of the division bench dated 19th August 2002 was the subject matter of challenge in SLP Civil number 24798 of 2002, which came to be dismissed by this court under the order dated 10th February 2004. In compliance of the order of the division bench dated 19th August 2002, a fresh redrawn state-wise merit list dated 19th May 2004 came to be notified by the second respondent appointing 259 candidates and at the same time cancelled the appointment of 47 candidates who were already in service since their names did not find place in the revised merit list at the state level. That the ousted candidates approached the learned single judge of the High Court by filing a writ petition challenging the redrawn state-wise merit list dated 19th May 2004 and the learned single judge by its order dated 24th May 2004 issued interim directions to allow such ousted candidates to continue in service until the next date of hearing. Meanwhile, contempt proceedings being COA number 22 of 2004 were also initiated against the second respondent for non-compliance of the order of the division bench dated 19 August 2002 and against the continuation of such 47 ousted candidates in the service. The division bench of the High Court, by its order dated 3/12/2004, disposed of the contempt petition with a direction that those who did not come within the merit zone in the redrawn merit list cannot be allowed to continue, and if any such person is being so continued, he will be removed as already directed by the order dated 19th May 2004 that came to be challenged in an SLP at the instance of the 44 ousted candidates who have been directed to be removed from service by the division bench by order dated 3/12/2004. Various interlocutory applications by a total of 22 candidates were filed for their impleadment before this court in the pending special leave petition, which was later converted into Civil Appeal number 4758 of 2006. This court, by its order dated 10th May 2007, without examining the inter se dispute of the litigant parties and taking note of the statement made by the learned advocate general of the state on its face value that all the 47 ousted candidates. Stop.